We recently saw substantial changes with immigration in New Zealand with a focus on the accredited employer work visa, as well as the addition to some work to residence roles and the removal of the bus and truck driver residence visa through the sector agreement. Now, it's that final one we want to look at today in a bit more detail. We've been seeing several questions popping up, both in the online forums but also to us directly, and we want to sort of cover one of those answers today. We've also been reviewing these changes that have come through, and we've found a very large issue, one that needs to be fixed by Immigration New Zealand, or is going to impact probably most of you who are looking to apply in the future for this bus or truck driver residence visa under the allowance that is still there. Now, I'm Arran Hunt. I'm a partner here at McVeigh Fleming, where I head up the immigration team. As always, this is not legal advice, it's just our commentary on immigration here in New Zealand. If you're looking for legal advice, please contact us at the address in the description down below or through the McVeigh Fleming website. Now, let's start with the question that has been raised with me several times. It relates to a section of the instructions. Now, as always with the instructions, if you ever hear me say one or two letters followed by a number, then typically I'm referring to the operational manual, which is the instructions that immigration must follow. I'm going to look at it now, but these are things that I'll refer to a lot in my videos. Now, SR 715 covers the work experience requirements. We will come back here shortly for INZ's issue because it does feature on this page as well as another. But for now, we're going to cover SR 715 FI. Now, this requires a 24-month period that will stop being counted. So that 24-month of work experience you need to apply for the residency will stop being counted if the applicant ceases to hold one of the visas in C above. Now, C is, of course, just this one listed here, and that covers any work visa, a critical purpose visitor visa with work conditions, or an interim visa granted when going between work visas. Now, SR 715 FI is saying that someone must maintain a visa, not that they cannot get a new visa. There has been some confusion with some people, and at least one advisor seeming to suggest that it means that you have to do your 24 months on one visa, and that if you have to change visa, you lose that experience. And that is not the case. The requirement is that if you cease to hold any of the visas listed, so any of the visas that are allowed up here, that is when it will stop being counted. And the fact that it allows for an interim visa here gives the suggestion that they are looking at people being able to count experience on more than one visa. Know that people are going to have to change visas quite often during that 2-year period. So hopefully that cleans that question up. Now, let's look at some of the issues. We'll start with a very small one, and we'll leave the big one for last because that requires a bit more explanation. Now, there is a minor issue here with actually what we've covered here is this interim visa allowance under SR 715C3. Now, this allows for an interim visa if someone is on a work visa or critical purpose visitor visa and has applied for another work visa. However, not all people in that situation would get an interim visa with work rights. So, for example, someone going from a post-study work visa to an accredited employer work visa, despite going from a work visa to a further work visa, they will not have work rights on that visitor visa. So it appears that they're saying you can claim that period as being working. Our advice would be advice to our clients would be that you cannot claim that point, that allowance as being working, because you were not working during that period, despite what it says here. And it could be said probably a bit more clear by the instructions. Now, the bigger issue is one that I've been very cautious about. I noticed it last week, and I wanted to run it past several of my staff, one who is a former immigration officer, just to get their take and make sure that I was actually reading it correctly. But I am usually pretty good at reading legislation and the operational manual. That's what lawyers do. It's going to impact a lot of people if it is taken as the way that it's been written. And I'm being very cautious here. We're going to explain as to why we think that's the case later on. We have been through these new rules as lawyers looking for big issues. This is the big one. This is going to cause probably the most mayhem unless it's clarified or fixed. The idea of the transport sector rules are that you had to do 24 months of experience in the previous 30 months. So you have to show that you've done those 2 years of experience to apply. We've had clients who have applied after 2 years of experience and gone on to get their visas. So S715 even allows experience to go back to 29 September 2021, which of course was the date they announced the 2021 residence visa. It's just over 30 months ago, so you'd be right to expect that any evidence from that date or just past that date, being 30 months ago, was acceptable. And you'd be right up until the changes were just made. Up until recently, that was how it works. You need to have 24 months of experience in the past 30 months, and it could go back to that date until 30 months ago. Now, if we look at SR710AI, now these are the list of jobs that people can apply for residence through under these instructions. Now, we do now see ship's master and deckhand. Until recently, these rules also had bus driver and truck driver. If you look at the bottom of the page here, you'll see links down the side here which link to previous versions of these instructions as they change and the date that they came into effect. So if we look at the previous one, we'll see bus driver and truck driver listed there, and it's the same with every other old version on here. We can look back seeing the bus and truck driver appearing on each of these old versions. Of course, the Minister has said that those who are already on their way to building up their experience can continue. This is covered under SR710B, which is right here. Despite AI above, acceptable employment also includes current employment in an acceptable occupation that was listed above at the beginning of the applicant's 24-month period if the applicant has completed 24 months of work in New Zealand in that occupation. Simple stuff for 4 sentences of instructions. We are going to sort of just break this down, but this is where the issue lies, and hopefully we break it down, you can see where that issue is going to be. Now, starting off here, we have despite AI above. That means that despite the jobs no longer being listed up here, that's not an issue. Despite that, so we can ignore the fact that they're no longer listed. They were listed before. Accepted employment also includes current employment in an acceptable occupation. That makes sense. That was listed in the above at the beginning of the applicant's 24-month period if they've completed 24 months of work in New Zealand. Now, as the jobs are no longer listed in AI, they were previously listed in there. So here we go, here's the most recent ones until last weekend. So they were listed in there. So when we're looking at the here, that was listed above. So the fact they're no longer there, not an issue as long as they were listed there previously. Now, some of you may have seen the issue here. If you have, well done. It's a little bit finicky to see, but it's this part here at the beginning of the applicant's 24-month period. Now, we've already seen that immigration has said that there's this 29 September 2021 date, and that's what the experience is counted from, but this isn't quite what it is saying here. What it is saying here is that the work experience of 24 months can begin as long as the occupation is listed in that list at the beginning of the 24-month period. So we count 24 months from when the job first appeared in this list above. Now, this list above first appeared on the 29th of May 2023. So the 24 months can only start accruing from that date. So any experience prior to that date, under the interpretation of this rules that we're taking, cannot be claimed for that 24 months of experience. You can only claim 24 months of experience from 29 May 2023, as that is the date that the occupation was listed above at the beginning of the period. So this period cannot, the experience period cannot predate when it first appeared in the list, 29th of May, 23rd of May, 29th of May, sorry, 2023. So with the change we had last weekend, we went from people who could take experience for the last 30 months, going back to 29th of September 2021, or slightly after that, with being more than 30 months ago, to those being able to apply with experience from less than a year ago. So in that very moment, there was a year and a half of possible experience wiped off that you can claim on. Now, we don't believe that this was the intent of Immigration New Zealand. We don't think that they wrote this with that intention to deny people the rules. That this was written some time ago, and it wasn't until now that this is taking place that we've sort of looked at it in more detail because it's now actually applicable and we've seen this issue. We will, however, be recommending to our clients not to submit an application for residence as a bus or truck driver under these rules until either they are corrected or immigration give very clear and written confirmation that they will allow for experience prior to 29 May 2023. Until that point, there is a real risk that immigration could decline an application, and if they were following the rules, they should decline an application. Any application made between 7 April 2024 and 29th of May 2025 for a bus or truck driver under these instructions should be declined automatically because of these rules as to how they are currently written. We'll hopefully have something from Immigration New Zealand shortly to either fix it or give confirmation around this. As I said, I don't think this was the intention of the instructions, but it is how we are reading them, it's how we are interpreting them. But that is all for today. I hope that made sense. It may not seem fair, but as lawyers we look as to what is in the law and how INZ would apply it. As I said, we're raising with Immigration New Zealand, and we'll come back to you when we get something from them as to whether this is how it's supposed to be taken or whether they're going to fix it. If you found this video helpful, please share it with others. Leave us a 5-star review on Google, link in the description down below, as it really does help us get the word out. Until next time, kia kaha, stay safe.